Everyone ready to start this glorious day? Good morning. Thank you, everybody, for coming in today. Excuse, just so everyone knows, I'm in another committee that's in the middle of a markup right now, so I will be handing the chair off to Mr. Boss. Thank you, sir. The chairman for VA is here, and he'll be taking that as soon as I finish my remarks. So, subcommittee will come to order. Good afternoon. We are here to discuss the 10 bills that would benefit veterans and their families. These bills would increase accountability and transparency for both the VA Board of Veterans Appeals and the VA Fiduciary Program. Improve the VA appeals process by building on the accomplishments of the Veteran Appeals Improvement and Modernization Act of 2017. Recognize and increase access to disability compensation for female service members who serve as members of the cultural support teams. Increase access to benefits for military firefighters and surviving spouses of veterans who suffered from ALS as well. And expand access to disability exams for rural and underserved veterans. I'm proud to have introduced two bills on today's agenda. H.R. 5890, the Review Every Veterans Claim Act, would prevent VA from denying certain types of claims solely because a veteran misses one VA exam. I believe it's ridiculous that under the current law, when a veteran misses their VA disability compensation and pension exam without providing good cause or rescheduling, VA automatically denies the veteran's claims. That's not legitimate governing in my opinion. That's working against the veteran. There is no reason why a veteran who has been pursuing their VA claim for years has undergone multiple VA exams should have to start completely over because they missed one exam. My bill would prevent VA from denying a claim solely because a veteran failed to appear for one exam while having an open VA benefit claim. The bill would ensure that veterans receive an access to a comprehensive decision based on considerations of all the evidence in their VA claim file, including every disability exam they have already appeared for. My other bill, 5891, the Veteran Appeals Decision Clarity Act, would build on Chairman Boss and House Republicans' work to modernize the VA appeals process. The bill would require the VA Board of Veterans Appeals to notify veterans of the evidence the board did not consider when making a decision on a veteran's claim. In return, veterans would have more transparency from the board. And when we allow our veterans to have access to all the information they need to decide whether they want to request the VA consider the left-out evidence in a potential future claim. The bill would also require the board to explicitly state in its decision which appeal forms successfully started an appeal and which did not. Right now, when the board overlooks or incorrectly rejects a veteran's appeal form as untimely but does not issue an explicit decision stating that the U.S. Court of Appeals cannot correct the board's mistakes, sending veterans back to square one. My bill would cut through the red tape and ensure the U.S. Courts of Appeals can hold the board accountable for their mistakes. Let me say this again, their mistakes, not the veterans. But right now, that falls on the veterans' shoulders. I look forward to working with Chairman Boss and my colleagues on this subcommittee to advance these important proposals today. I also appreciate the feedback from the witnesses who have joined us. And now I know my colleagues have worked hard on each of these proposals to improve the overall disability benefits process for the veterans and their families. This is a top personal priority for Chairman Boss and myself. Having gone through the VA disability claims, I welcome a healthy decision about the merits of all the legislations, and I am looking forward to the input from the VA and the other stakeholders. I appreciate the discussions we are holding today and I appreciate the discussions we are going to have today on the bills but that does not guarantee that all of them will move to markup, especially since some of these bills have a high cost and are not fully offset. I now yield to the Ranking Member Pappas for his opening remarks.
Thank you very much, Mr. Chairman, for convening this hearing. I want to welcome our colleagues who are joining us from off committee and all of the witnesses who are contributing to this session here today. Thank you for your shared goal of improving the lives of our veterans and their family members. Today we have several critical measures aimed at enhancing the experiences of veterans, their survivors, and dependents when seeking access to their hard-earned benefits from VA. For example, Representative Slotkin has introduced H.R. 3790, the Justice for ALS Veterans Act. This legislation would ensure that families of service members diagnosed with ALS receive critical assistance. While the cause of ALS remains unknown, it's established that veterans are twice as likely to be diagnosed with ALS compared to civilians. Alarmingly, ALS patients typically have a life expectancy of just 2 to 5 years, often leaving their families without necessary assistance. The proposed bill aims to broaden the scope of increased VA dependency and indemnity compensation to encompass the surviving spouse of a veteran who succumbed to ALS related to their service, irrespective of the duration of the veteran's affliction before passing. Additionally, my colleagues, Representatives Connolly and Trone, have introduced bills targeting fraud against veterans in VA's fiduciary program. These bills are H.R. 4016, the Veteran Fraud Reimbursement Act, and H.R. 4190, the Restoring Benefits to Defrauded Veterans Act. Together, these bills seek to safeguard and support veterans, their survivors, and their estates by providing avenues for compensation and benefits restitution in cases of fraudulent activity by a fiduciary, something this subcommittee has heard a great deal about. Furthermore, Representative Spanberger has put forward H.R. 4306, the Michael Lecik Military Firefighters Protection Act, named in honor of a Virginia veteran and firefighter who passed away in 2021 after a long battle with cancer. This bill aims to build on the efforts that were led in the last Congress with the PACT Act to address the legacy of toxic exposure among service members and veterans. Now, currently, VA doesn't acknowledge the direct service connection between military firefighting and cancer beyond 1 year following active duty. So this bill would establish the presumption that veteran firefighters who become disabled by serious diseases, including heart disease, lung disease, and certain cancers, contracted the illness due to their service in the military. This bill represents an important first step in tackling the toxic legacy of PFAS exposure among service members, but there's much more to do, certainly, on the broader issue. Of course, there are other bills today on the agenda from colleagues on both sides of the aisle, and I look forward to the testimony that we'll hear on them, and I hope it will provide this subcommittee with valuable information to refine and pass these bills before us to offer much-needed services to our nation's veterans and their survivors. With that, I yield back.
And the gentleman yields back. I now recognize myself to introduce and talk about the bill I have before the committee today. I'm proud to have introduced my bill, H.R. 5559, the Protecting Veterans Claim Option Act. My bill will remove the new and relevant evidence requirement for supplemental claims filed within 1 year of the VA denial of a veteran's disability claim. When the veterans file a supplemental claim, they expect VA to consider their additional evidence and issue a new decision on that claim. The new and relevant requirement is meaningless to the veteran who simply wants decisions on their claim. This is an unnecessary burden for the proof of the veteran. The veterans are forced to first convince the VA that their additional evidence is new and relevant. This process violates every veteran's right to continue to pursue the pursuit of VA benefit claim. This can add months and sometimes years of waiting to the process. Veterans are being punished simply by submitting additional evidence to support their VA benefit claim. My bill would ensure that no veteran has to jump through hoops in the claims process. My bill would also ensure that our veterans have all the information they need to navigate the appeals process after the board denies their claim. When a veteran appeals the board's decision to the Veterans Court, they often learn exactly what evidence is needed for them and to succeed in their claim for the VA benefits. My bill would allow veterans to submit such additional evidence to the board after the Veterans Court sends the case back to the board to fix its mistakes. My bill would ensure that each step of the veterans' claims appeals process is effective. We have more and more veterans submitting claims and coming to VA, and we owe it to these men and women to make the process as effective and efficient as possible. I look forward to the discussions on my bill today, and with that, I yield back and now recognize myself again. I like the flow on this. Here, you can have that. Thank you. All right, we've got a full agenda today. So I will be holding everyone to 3 minutes per bill so that we can get through this all. You know, Jeff Miller used to chair this, and he called this, whenever we held him real tight to it, we called it rodeo hearing, and that means you go, when the light turns red, you got 8 seconds to finish or we throw you out. So this morning we're joined by several of our colleagues, and I won't be throwing you out. We'll let you finish, okay? Both on and off the committee, who are going to be testifying about the bills they have sponsored. And now we first want to recognize Representative Self for his bills.
Thank you, Mr. Chairman, for holding this hearing. My bill is H.R. 5870, the Veterans Appeals Transparency Act, and I believe this bill represents a vital step towards making the appeals process for our veterans more transparent, fair, and streamlined. The board currently publishes the average time it takes for the board to issue decisions in cases on each of its dockets. These averages can be misleading, and those averages provide veterans with no accurate sense of where they are in line. Further, the board does not report to veterans, the public, and Congress exactly how far behind they are in working down their backlog of cases in each docket. One of the key provisions of my bill is the requirement for the board to publish information about which appeals in each of the board's dockets are actively working on during a given week. This is a critical step toward transparency and ensuring that veterans have a sense of where they are in line. Another important aspect of this legislation is clarification it provides regarding the appeals process. I'll get to that in just a second. My bill clarifies that the appeals process under the Veterans Appeals Improvement and Modernization Act was always meant to be streamlined. My bill makes it clear that this streamlined process, veterans have the option to submit a single administrative review request, such as a supplemental claim, higher level review request, or notice of disagreement within 1 year of the most recent VA denial of their claim. This streamlined approach is veteran-friendly because veterans can navigate a single appeal stream, and VA can easily track that stream. However, a recent legal development has brought complexity into the appeals process. The Terry versus McDonough decision by the Veterans Court interpreted the Appeals Modernization Act as allowing veterans to submit multiple administrative review requests against a single VA denial, as long as they file within the 1 year deadline. This has created a convoluted system that will undoubtedly be challenged in court by both veterans and the VA, and challenging to navigate. This convoluted system might just end up being more complicated than the legacy appeals system that the Appeals Modernization Act was intended to fix. My bill corrects the Veterans Court misinterpretation of Congress's intent when Congress passed the Appeals Modernization Act. This, along with your bill, Chairman, the Protecting Veterans Claim Options Act, will simplify the appeals process while protecting every veteran's right to appeal denials of their claims handed down by the agency of original jurisdiction. A clear and streamlined process is beneficial for our veterans. Ultimately, my bill restores clarity and efficiency to the appeals process, and I yield back.
Thank you, gentlemen, for yielding back. We now represent, yes, we do. we recognize Representative Spanberg, and you're recognized for 3 minutes to speak on H.R. 4306, the Michael how do you pronounce it? Lecik, okay. Military Firefighters Protection Act.
Thank you so very much, Chairman Bost. Thank you to the Ranking Member Takano. Thank you to the members of the committee. Mr. Pappas, thank you for your kind introduction of this legislation. Thank you for the opportunity to testify before the committee in support of my bipartisan Michael Lecik Military Firefighters Protection Act. I'm here today not only as a congresswoman, but also as a representative who had the privilege of getting to know Mike Lecik and his family, including his wife Tiffany and his 3 beautiful daughters. Mike was a former U.S. Air Force firefighter who selflessly served our nation. He deployed twice to the Middle East. He later became the chief fire inspector at the U.S. Army garrison Fort Gregg Adams. In 2021, Mike Lecik tragically passed away due to multiple myeloma, a rare and aggressive form of cancer that attacks the body's plasma cells. He was only 41 years old. Mike's service to our country undoubtedly led to his cancer, and civilian fire departments across the country recognize the connection between the chemicals used in firefighting and certain types of cancer. However, the Veterans Health Administration currently does not cover treatment costs for diseases like Mike's because the VA still inexplicably fails to recognize the direct service connection between military firefighting and life-threatening illnesses such as his, if it is 1 year, more than 1 year beyond active duty. This injustice must be rectified, and the Michael Lecik Military Firefighters Protection Act would finally provide veteran firefighters with the compensation, health care, and retirement benefits that they have earned through their service. This legislation would create a presumption that veteran firefighters who become disabled by serious diseases, including heart disease, lung disease, and certain cancers, that they contracted these illnesses due to their military service. This presumption of service-connected illness is so important. It would also extend the window of time for veteran military firefighters to claim presumptive service connections to 15 years. And by establishing this presumption, the VA would finally be able to provide long overdue benefits and treatment cost coverage to veteran firefighters like Mike, who gave so much of themselves to our country. I'm proud to lead this legislation alongside my Republican colleague, Congressman Don Bacon, himself a former U.S. Air Force chief. Our bill would, at long last, recognize the link between occupational hazards faced by military firefighters and the development of these devastating diseases. Scientific evidence demonstrates the connection between firefighting and the increased risk of certain diseases, and it's time for the VA to recognize this fact. Many states have already acknowledged this link, but the VA does not. We have bipartisan support to fix this issue, demonstrating that this is a cause that transcends party lines and unites us in the name of gratitude to our military firefighters. Throughout his fight with cancer, Mike never stopped advocating for his fellow veteran firefighters. It's why I introduced this bill. It's why I continue to push for it. And as members of Congress, in his memory, in his honor, we have the opportunity to make sure that his fellow military firefighters receive the care, the benefits, and the recognition that they have earned. Thank you to the committee, and I yield back.
Thank you, Representative Spanberg, and we appreciate it, and thank you for your testimony today. And I want to now recognize Representative Issa and recognize him for 3 minutes to speak on H.R. 1753, the JAX Act.
Thank you, Mr. Chairman, and thanks for this opportunity to talk about a small bill, 310 brave women who were CSTs. They did not fight, but they carried weapons. They carried 60-pound packs. They, in fact, as cultural support team members, were essential to our operations in Iraq and Afghanistan. As many of you know, within Islam, women have a special role, particularly in countries like Afghanistan, one in which they are uncomfortable or even, in fact, could become frantic if confronted by a man, let alone a man with a gun. In order to get cooperation and information and to save lives on both sides, the United States military employed these special brave women, many of them intelligence officers, but all of them willing to do everything their male counterparts did. We are relatively new to women in combat at this level, and as a result, it is not surprising that the VA, and for that matter, the Department of Defense, was not prepared to have their DD-214s and their VA records show this direct combat activity. But as we all know, PTSD and other injuries occurred during their operations, in fact, put them in a special category of people, mostly men, but 310 women. Currently, without a designation, these 300 plus CSTs find themselves being treated as non-combat individuals, not recognized along with their counterparts. In a perfect world, I guess we would simply update all of them to say that they were men. But since that's not in the making here today, let us simply say that this act designates them in a way, and a one-time way effectively, but a model for the future to make sure that women are recognized and treated for their combat activities equally. This is a bipartisan effort with more than 25 co-sponsors, and to say the least, we could have gotten more co-sponsors, but our goal was to keep it simple. This is something where we can cure a wrong by simply having a designation. And I want to close with just one thing. Many of you probably are aware that CBO decided there was a score. And I ask you, if there's ever been a time in which to look at CBO and roll your eyes, it would be this one. These women are entitled to what they are to receive. And if there's a change in what they receive, it's not a score, it's evening a score, making it right. I thank you for your indulgence and for moving this legislation. I yield back.
Thank you, Ms. Bamberger. Forgive my absence. Mr. Issa, having been part of the spec work community, working alongside women in combat, and I mean actual gunfighting combat, I support everything that you're doing. So I just wanted to add that. Mr. Subcommittee, you are recognized, sir.
Thank you, Mr. Chairman. Appreciate it. And my fellow members of the subcommittee for convening today to discuss my bill, H.R. 5938, the Veterans Exams Expansion Act of 2023. I represent southeastern Arizona, including parts of the Tucson metropolitan area, which also very rural areas in Cochise County, Graham County, and Greenlee County, which borders New Mexico. Veterans in our rural areas have historically had issues with access to care and benefits due to the lack of resources nearby. This bill aims to close those gaps by extending the license portability that VA-certified practitioners currently have, and also expands this authority to dentists, optometrists, and so on. This authority helps veterans who may have difficulty getting to a VA facility or a contract facility for their exams because of their disability or because of the rural area in which they live. We must meet our men and women who serve our country where they are. And it is in Congress's responsibility to ensure that the VA has the authorities they need to do so. I urge all my colleagues to support this legislation, and I yield back, sir.
Thank you, Mr. Subcommittee. As is our practice, we will forego a round of questioning for the members. Any questions may be submitted for the record. I now invite our second panel to the table. In accordance with committee rules, I ask unanimous consent that Representatives Issa of California be permitted to participate in today's subcommittee hearing. Never mind, he left. Everyone ready? All right, joining us today from the Department of Veterans Affairs is Ms. Beth Murphy, Executive Director of Compensation Services at the Veterans Benefits Administration. She is accompanied by Mr. Kevin Friel, Deputy Director of Pension and Fiduciary Services at the Veterans Benefits Administration, and Mr. Kenneth Arnold, the Vice Chairman of the Board of Veterans Appeals. I ask all witnesses, please stand and raise your right hand. Do you solemnly swear that the testimony you are about to provide is the truth, the whole truth, and nothing but the truth, so help you God? Please be seated. Thank you, and let the record reflect that all witnesses answered in the affirmative. Ms. Murphy, you're now recognized for 5 minutes to present the department's testimony.
Thank you. Good afternoon, Chairman Luttrell, Ranking Member Pappas, and members of the committee. Thank you for the invitation to discuss our views on pending legislation. Thank you for introducing my colleagues, Mr. Friel and Vice Chairman Arnold from the Board of Veterans Appeals. VA offers support for much of the proposed legislation before us today. We have provided detailed comments in the full testimony to include areas of support and concern, along with noting certain provisions that could be clarified or amended in the text of the bills. We look forward to collaboration with the committee on those provisions. I will briefly highlight key points on each. First, VA supports H.R. 4016, the Veteran Fraud Reimbursement Act, which would streamline reissuance of benefits in fiduciary misuse cases, enabling timelier payment of misuse funds to veterans and their survivors. VA supports the intent of H.R. 1753 to ensure proper recognition of veterans' combat service. However, we cite concerns with specific elements and have provided feedback in our testimony for the committee's consideration. VA appreciates the aim of H.R. 3790, which would amend existing law to extend increased indemnity and dependency and indemnity compensation paid to surviving spouses of veterans who die from ALS, regardless of how long the veteran had such disease prior to death. VA supports this bill, but requests amendment to include criteria for determining whether a disability has a high mortality rate. Moving to H.R. 4190, the Restoring Benefits to Defrauded Veterans Act, this bill would address reissuance of misused benefits in cases where reissuance did not occur prior to the beneficiary's death. VA supports the bill if amended. We have highlighted our concerns and suggestions in the written testimony. Regarding H.R. 4306, the Michael Lecik Military Firefighters Protection Act, this bill represents a veteran-centric approach to addressing health effects related to firefighting during active military service. VA supports this bill if amended. We recommend changes to enhance administrative efficiencies and ensure fairness and equity, such as removing some of the qualifying requirements. VA supports the intent of H.R. 5938, the Veterans Exam Expansion Act, to improve temporary licensure requirements for contract healthcare professionals performing medical disability exams for VA and for other purposes. VA would advocate to remove the license portability sunset date and expand the definition of a healthcare professional. VA appreciates the intent of H.R. 5890 to preclude VA from denying a claim for benefits solely because the veteran failed to appear for a VA medical exam scheduled in connection with the claim. However, we do have some concerns, including the effect the bill may have on practices of some in the for-profit disability benefits questionnaire completion industry. We provided additional details in the testimony and welcome opportunity to discuss those concerns with the committee. Regarding H.R. 5559, the Protecting Veterans Claims Options Act, VA cites concerns with part of the bill and does not support other provisions. In particular, VA is concerned that the bill would negatively impact progress made since implementation of the Appeals Modernization Act by rolling back some of that law's key provisions. We welcome opportunity to discuss the bill further. Moving to H.R. 5870, the Veterans Appeals Transparency Act of 2023, this bill aims to improve processing for claims for benefits by VA and transparency of actions by the board. VA is committed to make ongoing improvements to these programs. However, the intent of some of the proposed language is unclear. VA does not support the bill unless amended. We have provided specific comments in the testimony for consideration. Lastly, VA does not support H.R. 5891, the Veterans Appeals Decision Clarity Act, for several reasons outlined in our testimony, including that the bill would add significant delays to appeals processing timelines, increase the appeals backlog, and result in confusion among veterans. In closing, thank you again for the opportunity to discuss this important legislation to improve benefits and services for veterans, service members, survivors, and their families. We look forward to working with you and are prepared to respond to your questions.
Ms. Murphy, thank you for your testimony. We'll now move into line of questioning. Mr. Arnold, good afternoon, sir. VA testimony states that the Veterans Appeals Decision Clarity Act would add significant delays to appeal processing timelines. But the board judges should already know the time periods during which untimely evidence was submitted and therefore cannot be considered. So why do you think the general statement that my bill would require would add significant delays to the board issuing a decision?
Yes, sir. Thanks for asking that question. Basically, the board opinions have grown in length based on the procedural requirements. I mean, in some cases, they're as long as a Supreme Court opinion. In this case, what happens is when a veteran chooses under AMA to come to the board, there's an evidentiary window. Either they come in clean, everything that VBA, for instance, considered Is the record, consider that.
We can make believe that no veteran's going to come in clean. This is never, it's not in the cards, I don't think, but anyway.
Sir, actually, about 45% right now choose that option. Consider what VBA had and just make a decision, Judge. And then another percentage of the people say, hey, I got 90 days to offer additional evidence, so they can add 90 days to add or get delays on that. Or they can request a hearing, at which time they can offer evidence at the hearing, plus 90 days after that. So one of the challenges here is in the waiting period, for instance, for a hearing or for the court to get to the decision, very often the veteran will send in news articles or even thousands of pages of information for the board to consider, but it's outside those evidentiary windows. So I'm worried that a requirement like this would cause so much administrative burden to identify the time period that we received it and why it couldn't be considered, that it turns into essentially a gotcha exercise. You put the wrong date, and then it's a basis for remand from the court.
So the legislation is trying to streamline the process.
Yes,
From more or less what I'm understanding, you're saying is the veterans overloading the system with arbitrary, superfluous material that doesn't need to, is that the case? Because for us, we're trying to streamline it so the veterans are taken out of the equation when it enters into the VA system.
Yes,
and
sir.
I find it hard to believe through all the IG investigations that I've sat in front of today that it is on the veterans, it's the veterans' fault, and not, I'm going to throw this one at you, and not the VA's lack of ability to create a structured environment to process the applications appropriately.
Yeah, not at all, sir. The concerns that first of all, I'm going to say the board makes mistakes all the time. We're human. And this isn't an issue of the veteran complicating the system. The veteran's trying to just get as much information to VA as possible on their claim.
The VA is hand-walked through this process by all the VA staff, correct? More or less from start
yes,
to
sir.
finish.
Yes,
so I
sir.
don't really say that we can't put the veteran in the position that it's their fault. And I hate to say that, but they're not trained in law, and they're not the judges, and they're not the board.
No, sir. I'm not saying that at all. The overwhelming majority, almost all veterans come in represented. They get free representative
Sure. Yes, sir. I got-
representation.
yep, I got it.
So they are being guided through the process. But what happens is we provide direct interface with veterans even when they're represented, and they will send us information via the mail. It's often duplicative. I saw this news article in the VFW magazine. I wanted to share that. It's about Agent Orange. But it's a whole bunch of information that the board can't consider because the choice that they made when they came into the board with their representative on how they wanted us to review the case, this is a bunch of extraneous information that if we had to call it out specifically in our opinions and list each of those pieces of evidence and talk about when we received it and why we can't consider it, we're adding a lot of burden.
Yeah, so the challenge that comes into that, and where I have a problem is on my side, not only as a member of Congress but as a veteran, is that if the more information that I gather from your side, the better off I'm going to be or they're going to be. So I find it troublesome that there's more or less an irritability that providing the veteran themselves with more information, and that may be 2 sentences, it may be 3, and I don't know.
Yes, sir.
Again, you shoulder a very heavy rucksack, okay? But having answers, this is something I hear from my veterans all the time. The more information I can have from those that I'm engaging with, the better off I'm going to be in order to solve my problem. If I just receive a letter in the mail from the VA that says, hey, you've been declined.
Yes, sir.
And that's where this piece of legislation cleans the process up.
Yes, sir. So one of the most robust decision you're going to get out of the board is if we're denying, because we have to provide the reasons and bases for why we are denying your appeal.
But that's important, yes?
Super important.
And the veteran needs to know that,
They
correct?
absolutely do.
Okay.
Absolutely. So as a 30-year veteran and as somebody who's the beneficiary of getting our sole income as a family when I was growing up was my dad's 100% disability benefits and related, like free milk, free lunch program. This is super important to me. It's why I'm at VA. So I love what we're trying to do with these things for how we can benefit the veteran. This is one that I am so worried is just it's going to slow down how we do our decisions. It's going to create complexity in the appellate space with the courts, and I know some people probably have questions about that. That's going to be gotcha exercises that just contribute to the churn and keep more people waiting in line. That's my biggest concern.
Yes, sir. All right, I'll circle back. My time's up. I yield to the ranking, I recognize the ranking member for his Line of questioning.
Thank you, Mr. Chairman. Ms. Murphy, if I could start with you on H.R. 4306. This is the Michael Lecik legislation that Representative Spanberger spoke about before. This would establish a service connection based on a specific occupation, which is a first, I believe, as opposed to dealing with specific service dates and locations. But it's based on what we know to be true, where firefighters are exposed to toxic substances, including PFAS, through their work, and creates presumptives around that. You mentioned that you could support this legislation if amended. Could you explain a little bit further what you mean by that and how you would like it to be changed?
Thank you, Ranking Member Pappas. This is really a veteran-centric bill, as I mentioned before. What we've seen when we're talking about actual claims processing, the more complexities that you add to a process, the more difficult it can be to navigate for the claims processors and to get to yes for the veteran. So in particular, the requirements for a 10% minimum evaluation, the 15-year disease manifestation period, and the aggregate of 5 years, adding up 5 years of service in that particular occupation, are some of those complexities that would make this more difficult potentially for our claims processors. So stripping out those requirements, that way we're not hunting for additional records. It looks like this person was in 4 years and 2 months. We need, 10 more months. Those are the sorts of changes that we're advocating, is to strip out those complexities and just make it more streamlined for our claims processors and for the veterans.
Okay. And can you address the broader issue about PFAS exposure? I know we've got hundreds of military bases around the country where there's PFAS contamination that our service members have been exposed to. We're talking about drinking water near or on military installations. How can VA address this challenge if we do want to move in this direction of ensuring that people get access to care and benefits through their service who have been exposed to these substances?
Certainly, sir. This is a great start, Congress putting this presumptive in place. I will tell you that we on the benefits side have been working increasingly more with our VHA partners in the Health Outcomes Military Exposure or Home Office, who they're doing the surveillance, the research, studying the PFAS issue. It's an important one, and I think it's coming to a head, but certainly not fast enough. This bill would move us forward faster on a topic that is recognized and is being researched, but is just not there yet on VA side.
Okay, and switching gears to H.R. 3790, this is the ALS Veterans Act legislation that Representative Slotkin has introduced. You mentioned that you would support this if it was modified to include criteria for determining whether a disability has a high mortality rate. I'm wondering what criteria VA uses to determine if a service-connected disability has a high mortality rate currently, and how these criteria could be incorporated to ensure consistency moving forward as we consider this legislation.
Chairman, I'm sorry, Congressman, I'm going to turn to my colleague, Mr. Friel, who's the expert in this matter.
Yes, thank you for the question. So to clarify the ALS, today, if a veteran passes away from ALS, the surviving spouse is entitled to DIC because we've made that connection. What this law will do, what this proposed bill would do, was allow us to pay them the additional 8x8, which is where we identify that a veteran was 100% for 8 consecutive years and the spouse was married to them for that time frame, and pay the additional, like today it's $313 in benefit. Where we talk about the high mortality rate, our concern is that it's not just about mortality, right? I guess it's about speed, and I'm not trying to be cold-hearted, but speed to death, right? So from onset of the disability to when the beneficiary passes away, because we know ALS is a rapidly progressing disease and doesn't give the veteran potential to meet that 8-year period. And so that's kind of where we're trying to look at the requirement for the the definition of the high mortality rate as it relates to a disability that is, has a short lifespan from onset to the potential death of the
Well, I guess my question is, shouldn't we be supporting the work that VA clinicians and researchers are doing around that as opposed to Congress making a determination?
Well, yes, we were just kind of looking for clarity on Congress's intent. Is 5 years? Is it 7 years, like, what is the actual time frame that we would be looking at where we would consider that a high mortality rate?
Okay, well, maybe we can keep working to refine that. I appreciate the flag and yield back my time.
Thank you, Mr. Pappas. Chairman Boss, you're recognized for 5 minutes, sir.
Thank you, Chairman. Ms. Murphy, with the AMA, the supplemental claim option was intended to allow veterans the option for filing additional evidence for their claim. But under the current law, when VA decided that the veteran did not file a new and relevant evidence, VA refuses to issue the decision on the claim for the benefits. Now, this was effectively has forced thousands of veterans to start the claim process all over again. How do you think my bill would ensure that the veterans receive a decision on their VA claim that they can then appeal?
So Chairman Bost, if I could make kind of an overarching statement about many of these are appeals-related bills. I think VA's position is that we certainly want more clarity.
Right.
We want it to be more streamlined, easier to understand, simplified. And AMA has been in progress now for 5-6 years. We've learned from that, and I think the process that we used to create the AMA legislation was one of the most solid that I've heard great feedback from stakeholders. The fact that folks got to come to the table, be heard, give their perspectives, and really contribute to a holistic change from a system that wasn't working for anybody.
Right,
VA
it was
or
not
veterans.
working.
So I think to the extent that we can continue that forward movement collectively, rather than having maybe one-off changes and tweaks to the process, would be what VA would support more.
Okay.
Does that
Let
make
me say this, because you know how much I was involved with this.
Yes, absolutely.
Let me say that and then I'm going to ask Mr. Arnold a question as well, but like any legislation, once we put it in place and then we start implementing, we see how different agencies, it's not doing everything that we want. So we want that's why we tweak. And it is, and it was our concern, the long wait times. And we don't want to tweak and cause those long wait times to come back, but we also know where we've seen the flaws. And so as we're trying to work through this, it is for the veteran that we're trying to make the decision so that their claims can be handled. There has to be the frustration that a person could feel if all of a sudden they said, okay, I've got new evidence, and now all of a sudden it just gets dropped and we're going to start the whole thing over again. And that's the frustration we feel. But Mr. Arnold, I'm going to ask you something here. In your testimony, you suggested that veterans would file more appeals with the court simply to add additional evidence that would further delay the final resolution of the appeals that they originally filed. I just want to let you know I disagree with that, okay? They don't file appeals court to prolong their claim. They're wanting to get their claims taken care of. They want a final correct decision on their claim from the board. But after the court sends a claim back to the board, veterans can't file additional evidence to the board, and their only option is start a new claims process all over again with VBA. Why do you think the focus is on returning the claim to VBA to look to additional evidence rather than making the board, making it so sure that the board can consider evidence when it is fixed, when it's just fixing a mistake that they may have caught?
I'm button challenged, sorry, sir. I started on the day that AMA was implemented fully in 2019. So I wasn't at the table in 2017 when all of the sausage making happened. But as I understand it, and the evidence is proving this, that there was in all of the debate amongst the stakeholders, it was really a really important facet of what I think is incredible legislation under AMA. As a veteran, I am so proud of that. I mean, you built a 4-lane highway.
I am too.
Yeah, you built a 4-lane highway, but what we're not recognizing is all the tractor trailers that are on it. And I got that analogy from our new chairman when he started a year ago when we were educating him. He goes, this is a beautiful 4-lane highway. There's all these tractor trailers that are blocking progression. And I would view what we're trying to do here in a piecemeal fashion is it is time for people to step back and look more holistically. This part of the legislation that's proposed would add a new 90-day window when one important facet that everybody agreed to with AMA for accountability purposes is the evidence and information that was considered by VBA, that's what the board looks at. Thumbs up, thumbs down, did you get it right? Because you said no. And we added a kicker as part of the compromise. You can have 90-day windows at the board if you so choose to supplement it. You got something else you want to tell us after getting that no from VBA. So it was, I'm looking at the case plus what you want to add. Then we make our decision. It's only going to the court, really, if we denied it. So, or if we didn't, although that's not always true either. But if we deny and we give the reasons and basis for why we have to deny, it comes back from the court oftentimes to say, explain further. So the court's looking at the case that the board looked at. Here, we'd be talking about, now it's an entirely new case. And I'm gonna be honest, given the passage of time, sir, for how long this whole process takes with the court, and something that I'm really glad you're pointing out, what happens is when it comes back to the board, the conditions often gotten worse. It's a new case. Somebody's been waiting an extra 2 years. Now their foot's numb from their back, and it wasn't 2 years ago when they were at the board. The challenge with that is then there's new medical evidence that really, we're not supposed to play doctor at the board. We can evaluate the evidence that does come in, but 99 times out of 100, we're gonna have to say, we gotta send this back to VBA anyway to have them evaluate this new set of conditions that the veteran's facing. That's what I'm worried about, because we very liberally grant delays when people need evidence for good cause, and it's not uncommon to see multiple additional delays. I want the veteran to get the fastest decision they can. If the board gets it wrong, heck, I want the court reverse it and grant. Please do not make these veterans wait any longer. So I'm with you, sir. Our concern with this was it's adding delays, and we actually can't really solve it in most cases then.
I'm out of time, but we'll talk more about this, I guarantee it.
Yes, sir.
So I yield back.
Thank you, Chairman Boss. Ms. Ramirez, you're recognized for 5 minutes.
Thank you, Chairman Luttrell. You really are committed to making sure that we experience how it feels physically on the other side. So I appreciate the seating chart here. I want to transition and first to say thank you to the witnesses that are here today. I also want to talk about the importance of uplifting and amplifying the contributions of women veterans. Even as a member of Congress, look around. I find myself often being the only woman in the room on this side, and certainly in many more cases, the only Latina. And I think it's important to acknowledge that and how critical it is for us to be in these spaces, certainly for me to be able to serve my community. And while I know that our women in uniform don't serve for recognition, their sacrifices and their contributions are too often overlooked. That's why it's so important that our servicewomen and their contributions to our country and our communities are uplifted and truly recognized. So, Ms. Murphy, I first want to ask you a quick question around the Cultural Support Team program. Can you describe how important the Cultural Support Team program is to achieving the U.S. military objectives?
So thank you for the question. We have been in initial conversations with the Department of Defense, our colleagues in DOD, about what this cadre of service persons did, what their roles were, and we're still in those early learning phases. So we're in that gathering information from DOD to understand what their role and missions were.
Okay. Well, can you describe how important it is that those service women be fully recognized for their engagement in combat in order to receive the benefits and care that they've earned?
So we go out of our way. We bend over backwards. Every claim we touch, we look at all the facts and circumstances. We take the evidence into consideration. Sometimes in cases maybe such as this, when all of the information isn't there that we need to demonstrate what that service member did, where they were, what may have happened to them during service, that's where we're kind of hamstrung in the claims process. So the more transparency that we could have and the more information about this cadre of individuals, we would be better positioned to assist.
So a couple of yes or no questions,
Yes.
and thank you for your response. In your opinion, have service women been historically not fully recognized?
I don't have an opinion on that. We just take each case by case, and we process the claims
Okay.
and proceed that way.
Let me ask you a follow-up, and this is also a yes or no, and maybe you could answer yes or no in this case. Do you think this is something that the VA should actively work to correct, to make sure that service women are fully recognized?
Yes, we should do everything we can to gather all the necessary information so that we can say yes on every case that we encounter, that we're able to.
Yeah. Well, thank you so much, Ms. Murphy. During my time in the committee, one of my priorities has been to address fraud and waste at every level, from education to veteran benefits, and we certainly have to strengthen the protection of our most vulnerable communities, and that includes veterans. Ms. Murphy, your testimony provides that this bill will enable timelier reissuance of misused benefits to veterans and their survivors, and enable more effective application of VA resources towards more productive methods of oversight to protect beneficiary funds. So let me ask you a follow-up question. In fiscal year 2022, there were only 25 investigations into fiduciary misuse opened and referred for prosecution. Of those 25, 8 cases were declined for prosecution. Are all instances of misuse by fiduciary intentional?
So, ma'am, if I could turn to my colleague, Mr. Friel, he is the subject matter expert here. Thank
Great.
you.
Thank you.
Thank you for the question. No, not all issues or circumstances of misuse are intentional. In some cases, we find that the individual just made a mistake. They withdrew money from an account, used the wrong debit card or things like that, and we work with them to correct it, identify the circumstances. And so, I don't know if is that the question?
Yeah, no, that's helpful. I mean, I guess just in my last 20 seconds, how are funds that were negligently misused recovered?
So we actually create a debt for them that is transmitted out, and we give them an opportunity to repay. If we are unable or unsuccessful with that, we transmit that debt to Treasury, and then Treasury does their piece in garnishing, tax returns or other assets to collect that debt.
Well, thank you, Mr. Friel. With that, I yield back. Thank you, Chairman.
Thank you, Ms. Ramirez. Mr. Self, you're now recognized for 5 minutes.
Thank you, Chairman. I've heard a great deal here about concern about adding to the VA workload. I'm addressing my HR 5870, Veterans Appeals Transparency Act of 2023. Mr. Arnold, is it true that the law requires the Board of Veterans Appeals to issue decisions in docket order? So doesn't that mean that the board is already carefully tracking and selecting the range of dates of cases for each docket, each board docket, that are being assigned to veterans law judges for a decision at any one time? You're tracking it at any given time.
We know what we're distributing for cases at any given time, sir. The pace at which they're decided when they're with the judge, there's some variability on that. But
Got
yes,
it.
sir.
So given those two answers, can you elaborate on why your testimony states that it would be administratively burdensome to simply publish what the board is already doing?
Yes, sir. Administratively burdensome, but actually our greater concern, even though it says that, is how confusing it would be for the veteran. Which
That's
is what
my
I
next
care about.
question.
Oh, yes, sir.
So-
Okay. So let me go to administrative burden
Right.
first of all, sir. So I'm going to tell you that the line is changing at every moment of every day. So to understand how appeals move through the board, in docket order, there's a bunch of exceptions to that. So in any given year, let's say we do 100,000 decisions. Last year we did 103,000 plus. 100,000 decisions. Every year, 30% of those, so 30,000, are advanced on the docket. We get notified, this veteran moved to hospice. This veteran
let me-
stage 4, so they jump to the head of the line.
Let me stop you there. How far do they move?
They move to the head of the line.
To the head of the line?
Yes, sir. Every time I've got somebody who's, like, say, a stage 4, they move to hospice, they're at end of life, over the age of 75, very advanced age, there's a motion, or on the board's own motion, they are moving to the head of the line in the fast pass lane.
So how often do you publish them now?
In terms of what we're doing with dockets?
Yeah.
So what we're doing now, sir, is because the range might be 10 years in a given week. I could be doing a case that has a 2004 date and a date.
How often do you publish?
We publish monthly. We update our average days to complete them and average days that cases have been pending by docket.
Okay, so I'm still not following why it would be burdensome if you took a weekly update or whatever, but let's move to the misleading. I assume it's because of the changes that you're talking about.
Yes, sir.
So I accept the fact that you might have 30,000 in a year, did you say?
Yes, sir.
That move to the head of the line. So would it not then be possible to have a separate category of them that you notify them as opposed to simply publishing? I got the issue.
Yes, sir. So the better way to explain this is
Because
that's
I
30%.
don't want the outliers to drive the entire
Yes, sir.
system.
Yeah, so that's 30% of what moves in the line. I still got 200,000 in line at the end of
Correct.
the year, which is unconscionable to me. So then there's another 15% that come back from the court. They go to the head of the line by law. By law, they must be expedited. So that's the second category. So now I'm up to 45%. Then everything that has to go back to VBA, either as a pass-through remand from the court, or because we say, I can't call this thumbs up or thumbs down. This needs a new exam, you didn't have a duty to assist, that's another 25%. So 70% of what we put out every year essentially cuts the line. And that's
Okay.
happening constantly.
Okay,
Yes.
I've got that, but if you did it, then the next question is, once they jump to the head of the line, how long is it before they get heard?
So again, it depends on how many the judge can decide. Right now, we're deciding on average of, say, 2,000 to 2,200 cases a week.
Per judge?
No, sir, at the board.
Aha.
Yes,
So
sir.
we've whittled it down quite a bit. I still think, and I've got 25 seconds from this discussion, you've enlightened me, and I appreciate your answers.
Yes, sir.
But I think we can do a better job, and that's what this bill does. Now, I've not even gotten to the other issue in the bill, but great discussion. I think we can do a better job in the bill of making it transparent to the veterans. I yield back.
Thank you, Mr. Self. Mr. McGarvey, you're recognized for 5 minutes, sir.
Thank you, Mr. Chairman. Switch gears just a little bit here and appreciate what you guys are doing. Also, thank you all. One of the things I try to say at every committee hearing is this committee is united in its effort to protect our veterans. I think we do share the common mission of making sure that the men and women who put on a uniform to take care of us, that we're doing everything we can to take care of them. That we're doing everything we can just as when they go in as when they come out. So one of the things we know is that in the Veterans Board of Appeals, we're dealing with our veterans who are out of the service. But we're taking care of them, right? And the people who are taking care of them are, in a way, still part of the VA, still on their active duty tour. And in order to make sure that we are properly taking care of our veterans, we've got to make sure that we have enough people within the veterans system who are qualified and ready to take care of them. And so one of the things I'm worried about is the adjudication of appeals and making sure that those appeals are adjudicated correctly, because I don't think any veteran should ever have their earned benefit taken away from them. I know you guys probably share my feelings on that. So while there are several bills on the agenda today aiming to enhance service and transparency at the Board of Veterans' Appeals, I want to highlight that there is not a bill to improve the recruitment and retention of the Board of Attorneys who are on the front lines of moving those veterans' claims forward. Again, we're taking care of our veterans. They've done their tour. They've earned this benefit. We have people right now taking care of them who are still on the front lines and need help. The Board of Veterans' Appeals currently faces a 7% attrition rate in board attorneys, which is well above the average in the federal workforce. This is why I found it surprising that the board downgraded the full performance level of board decision writing attorneys hired after November 2021 from GS-14 to GS-13. For such a small but critical subsection of the VA workforce with fewer than 1,000 decision writing attorneys, it seems like a misstep not to fully compensate our public servants and have the best tools at our fingertips to attract the top talent for our veterans. Again, these are the people who are processing these claims to make sure our veterans get the benefits they deserve. So, Mr. Arnold, what can this subcommittee do to help address this counterproductive policy to improve recruitment and retention at the board, which is going to make sure that veterans, including those in Louisville, including those in Kentucky, who are waiting for appeal decisions, have their appeals handled quickly by the best and by the brightest?
That's a great question, sir, and I'm really glad you asked it. First of all, I'm proud that in the 5 years I've been at the board, the attrition rate for attorneys has dropped from 13.9% in FY18, that's what I inherited, to 7.4. We got a ways to go. Like you said, 7.4 is not acceptable to me. The one thing I just want to correct, sir, is we did not downgrade our attorneys from GS14. We did change our automatic career ladder system, where there's an automatic, assuming successful performance, up to 13, and then there's, I'm going to call it a competition, but not with numbers attached to it. There's essentially an evaluation. Are you ready to make that step to as a GS14 attorney, where we're relying on you more than you're relying on us to help learn the craft on that? And this was an important development in our attorneys. I'm going to say the Board of Veterans Appeals has become really an employer of choice in a lot of different areas in terms of the diversity that we're able to hire and the scope and breadth of people we're attracting. Last year, our open announcement, we had 1,705 applicants. We evaluated or interviewed 600 and almost 700 of them. We extended offers to about 300, and we onboarded over 200 so far this year, and we're going to rinse and repeat. We've got people who want to come to, we changed our workforce being virtual. That was something that we really struggled with. Did they need to be in the office, especially in the early years? And that's contributed to, we got people all over the country now that are really kicking it. And our productivity shows what we're gaining from it. We increased our attorney ranks by 16% last year. So we're beating the attrition curve, but again, losing one is not okay for me. I'll tell you there's some internal policy stuff with respect to retention. The law's already on the books, but we have some VA policies that we've been working on really hard to allow the ramp-up time for attorneys where we don't have to make a go, no-go decision as quickly on, hey, they're going to be able to swim here as fast as we're trying to move through the veterans line. So thank you, sir.
No, thank you, and thank you, Mr. Chairman. I yield back.
Thanks, sir. Mr. Crane, you're recognized for 5 minutes.
Thank you, Mr. Chairman. I was told it was going to be Mr. Subcommittee next, but I do appreciate you sticking me on this side.
You're welcome.
All right.
They went by looks, so Mr. Crane, you are next.
What did you say?
They went by looks.
Yeah,
So,
yeah.
you got it.
Thank you, sir.
We can shift over to Mr. Subcommittee if you'd like.
No. I'll take it now. Thank you. First question, I consistently receive feedback from veterans in my district regarding significant shortcomings in the VA's claims processing. These ongoing issues result in delays and denials for veterans, mainly stemming from mishandling the review of new evidence submitted by veterans, contributing to major setbacks. Specifically, Ms. Murphy, when the VA recognizes a deficiency in new and relevant evidence in a supplementary claim, does this obligate veterans to restart the entire process for claiming compensation?
Thank you for that question. It depends on the case. I know that sounds like not the answer you're looking for, but when we're looking at claims, we're looking at supplemental claims. We do have two different lanes that were created by AMA. If you have a closed record, we go to the higher level review. If there's additional evidence, that would be a supplemental claim. The new and relevant evidence, it helps us manage the work. It helps us make sure that actionable claims are being considered and moving forward. And we're trying to avoid just churn or rehashing if the same or similar evidence is received over and over again. It helps us balance our resources and make sure that those actionable claims can move forward more quickly.
Thank you, Ms. Murphy. What type of communication is the veteran receiving it typically at that time the decision is being made?
So there are notification letters at different stages. We received your claim. You have this option. This was the decision on your claim. Here are your options for, higher level review, supplemental claim, appeal. There are follow-up letters that are sent. We also have a very robust call center. They're answering millions of claims a year. Inquiries a year, and they are available to answer questions. I also want to give credit to our VSO partners and other advocates who assist greatly in this process.
Thank you. This is a follow-up for my colleague, Mr. Luttrell. Mr. Arnold, VA's testimony refers to letters that the board sends veterans when the board could potentially reject their notice of disagreement. He wasn't talking about those letters. He thinks those letters are a good thing. What he's really talking about here are the letters that the board administrative staff sends veterans, letters actually rejecting their appeals. I think it is unacceptable that veterans must dispute those rejection letters in order to get a decision from a board judge that the court can review. Mr. Luttrell's bill would get rid of that unnecessary hoop that veterans have to jump through just to get their notice of disagreement in front of a board judge. His bill would ensure that any board rejection of a veteran's appeal can be reviewed by the court, and his bill would also ensure that the board will be held accountable for when it improperly rejects a veteran's appeal. Do you agree that when the board improperly rejects a veteran's appeal, the board should be held accountable for that error?
I absolutely do, sir, and we have a process in place to do that. So I think there's some confusion around this, but when a veteran, we get thousands and thousands of appeals on a weekly basis, when they file their notice of disagreement, if it's timely or not, yes, we have administrative staff who are essentially hand jamming that into the system. This is where I mentioned earlier, and I really appreciate Chairman Luttrell's comment about mistakes and board being accountable for mistakes. Mistakes do happen.
Absolutely.
That letter notices the individual, if you think we got this in error, please tell us, because it's then going to go to a board member judge. I created an office of the clerk of the board that is headed by a judge right now. It'll be headed by an executive board member with a presiding judge when we're done. But right now, a presiding judge is there to rule on that when it comes in and actually give a formal determination. So they're not waiting. They're not waiting for 2 years in line, waiting for it to actually get distributed to a judge, which is one thing I worry about.
Thank you. Real quick, what does that accountability look like, Mr. Arnold, when there is a mistake like that?
For the individual employee or for the judge or what? Sir, it runs the gamut, and it kind of depends. There's actually an en banc decision that we got in the Kearns case that went for over 2 years up in the Court of Appeals for Veterans Claims, where we were notified when that mistake was made. We tried to immediately rectify it, and then went on 2 years of litigation to eventually be dismissed because we docketed it. We docketed that appeal. And it occurred in the first week of when we were evacuating for COVID, so that in March.
So that really doesn't answer my question as far as accountability.
So that was a set of circumstances where the mistake that was made at the time when we were converting to all virtual operations at the beginning of COVID, we extended a lot of grace to the individual that made that miscount. I think they were off by a day or two when they did it. So in that particular case, there's no formal repercussions for that other than essentially a counseling.
Can you give us an example of any repercussions or accountability that's actually that employees are held to when mistakes that affect veterans' lives are?
Sir, I wouldn't get into personnel actions in this kind of forum, but I'm happy to talk about that offline in terms of how we hold people accountable.
Is that secret information?
It's not secret information, sir, but I wouldn't talk about, you asked for an example on a particular case, and I'm super cautious about talking about any particular set of circumstances on how we handled it.
Okay, well, this is the VA committee, and we're asking about accountability. You said that you believe in accountability, and you said that it happens. We're just wanting to know, what does that look like? No, nobody's asking for an employee to be thrown in prison or to be,
yes, sir.
Whipped.
So generically speaking, so we created an office of the clerk of the board that has been now built out over the course of the last couple of years. It is currently headed by a dual-hatted executive. We're in the process of creating another senior executive position to oversee this function. There's a presiding judge who's detailed there for up to a year. So they oversee right now this whole process. So the administrative, from inbound operations like you're talking about here, when somebody files an appeal, and they're responsible for accountability in that whole process for how an appeal moves through the board, from the time it's filed till the time a decision goes out the door. I will say one thing I'm the most proud of is how the veteran trust increases in the board throughout that journey. It increases about 10 to 11% in trusting the board to above 50%, which I find really incredible when we're only granting about a third of the time. And almost 20% of veterans say when they roll craps and they get a denial at the board, when they get that final decision, they say they trust the board. And that's because of the way we handled it and the way we were accountable for ourselves and the way that we educated them for why it was still a no. So I appreciate it, sir. I really do. Accountability is a big watchword for me.
Yeah, it sounds like a watchword, but yet, with all due respect, sir, it didn't sound like you gave me any example of any accountability that any actions that are taken at all. And that, honestly, sir, that's one of the biggest problems with the American citizens and the U.S. government is that they feel as if there's never any accountability. And I've been trying to ask you for the last 3 minutes, can you give us an example of any administrative actions, accountability that's been taken when mistakes are made on these claims, and yet this panel has not heard any. That's a problem. Thank you. I yield back.
Thank you, Mr. Green. Mr. Subcommittee, you're recognized for 5 minutes, sir.
Thank you, Chairman, and thank you to the panel for being here. I just a few minutes ago, I talked about the bill, of course, and a little bit of my district, but just to reiterate, I serve in Arizona's 6th congressional district, southeastern Arizona, and I have over 70,000 veterans in my district, 2 military bases, both in Tucson, the DM Air Force Base, and also in Sierra Vista, Fort Huachuca Army Base. So very important issue for in my district. So I have just a few questions, and I'm going to direct them to you, Ms. Murphy. That's so the first one: how has the temporary authority of license portability granted in I-6 and Row been useful for veterans in more rural areas, or those veterans with issues traveling to their exam appointment? From the 5 counties that I serve in Arizona, 4 of those are considered rural counties, and even the 5th, Pima County, has some areas that could be rural as well. So very important question for my district.
So Congressman, the ability to use contract exam support to augment what VHA's ability to conduct CMP exams, it has been tremendous. It's been phenomenal. And the ability to have that flexibility to utilize providers across state lines in rural areas has further enabled that support. So it's been essential.
Thank you. Would you mind also, Ms. Murphy, elaborating on the VA's concern that my bill does not adequately cover the definition of a healthcare professional?
So I want to clarify that we're thankful and appreciative of all the expansion in this area. So I don't want to come across that we're not appreciative. I would ask my colleague, Mr. Friel, to expand on your question.
Thank you. So what VA is asking is that we actually get a little more expansion into the bill. We, as Ms. Murphy said, we appreciate the expansion that's been granted, but we would also like the opportunity for VA to be able to identify and designate, specific physicians' dynamics that would meet the need of VA without having to have a congressional mandate, to identify this particular physician group as being acceptable for VA purposes. And so allow VA to do that, which would allow us to expedite, treatment for when the condition is something that we don't yet have a physician that's covered for it, and allow VA to opt that particular group of physicians into the program.
Thank you to both. Last question, Ms. Murphy. How do you think, talking about here the expansion and the extension of the License Portability Authority, how will that contribute to veterans receiving more timely and accurate decisions?
It will be a great expansion. Being able to identify which healthcare professional that we deem necessary to provide the CMP exam, any of that flexibility, any of the portability that comes with that, like I said before, it just further expands our ability to go find the veteran where they are. We've heard over the years concerns about veterans who've had to travel long distances for their C&P exam. That's not something that we want to put them through. So any of these authorities enable us to meet the veteran where they are more effectively.
You know, we've got a few more seconds here, and I can either yield it back to my friend, Representative Crane, to continue the exchange with Mr. Arnold, but I think I'll skip on that for a second. Although I am very interested in the accountability as well, I think that is essential in all that we do. And kind of like in the same light here, when you did this expansion, I think for us here, and this is part of what I think Mr. Crane was getting at, is important to know how this impacts people and give examples. Not always were we asking with name and last name on things, but I do think it's important to, when it comes down to accountability, get some guidance of how you usually approach these kind of things. I think that's important to us to better understand and actually to some extent support whatever effort is out there but we need to better understand that. Now, in this case with Ms. Murphy, you talked a little bit about how this impacts and gave a few examples. Can you just give me in the last 20 seconds how this exactly would help and maybe just a couple of examples on that?
So if we're speaking still about accountability, sir?
No, I'm sorry. I went back and forth. You're
Okay,
right. No,
sorry.
I'm talking about the expansion and the extension of the license portability.
Certainly. I think if we could ask for, still one more thing is expanding or taking away any of the sunset provisions so that we don't have to keep coming back and asking for extension would be also something that would be very helpful.
Thank you. I yield back, sir.
Thank you, sir. In accordance with committee rules, I ask unanimous consent that Representative Tone from Maryland be permitted to participate in today's subcommittee hearing. Without objection, so ordered. Mr. Tone, you're recognized for 5 minutes, sir.
Thank you, Chairman Luttrell, and thank you, Ranking Member Pappas, for its hearing today to review legislation will help support our veterans. I was an honor to serve on the DAMA subcommittee last Congress, and I'm thankful to have the opportunity to testify on behalf of my bill restoring benefits to Defrauded Veterans Act. I want to thank my co-lead, Mr. Subcommittee, a member of this committee. Thank you for your leadership in advancing this bill. As we approach Veterans Day, we're all reminded of the courageous men and women who have dedicated their lives to our country. It's not our job to ensure we pass legislation that improves their quality of life and tackles the various challenges that they face. Today, as a proud son of a World War II Navy combat veteran, I'm here to shine a light on an issue that affects far too many of them: fraud. Many veterans fall victims to financial predators, online scams, identity theft. These veterans are then exploited out of their benefits that they've so rightfully earned. Last year, the Federal Trade Commission reported over 195,000 complaints from military consumers, including over 150,000 reports from veterans and military retirees. The military community reported monetary harm over $414 million of fraud, an increase of 50% from the year before. Under current law, if a veteran passes away before their case is resolved, the family cannot be reimbursed for those lost dollars. Unacceptable. Our bill, the Restoring Benefits to Defrauded Veterans Act, will help those veterans and their families reclaim the defrauded dollars and give them access to the money they're entitled to. This legislation requires the Secretary of Veterans Affairs to reissue misused benefits to the beneficiary's estate in cases where the beneficiary passed away before that reissuance. While we ask so much of our service members, we must never forget their in-service has been on the families who are there to support their systems back home. It's the best that we can do to ensure these earned benefits stay with their loved ones. I encourage my colleagues to support this common sense bill to help our vets and their families reclaim defrauded dollars and give them access to money they deserve. Thank you, Mr. Chairman, and I yield back.
Thank you, sir. Ladies and gentlemen, thank you so much. It's a heavy rucksack that you carry. We know that. We understand that. We listen to our veterans in our districts. It is our job to explain to you what we're hearing at our level. It is our job to provide oversight so that these fraudulent waters are streamlined in a way that the ship will sail smoothly. And it's not an easy task. The machine that you work for is incredible, but it's very important. So thank you very much for coming today. And on behalf of the subcommittee, I thank you for your testimony and joining us. You are now excused, and we will, for a moment, and then the third panel will come to the witness table. Have a blessed day. Good afternoon. Is everyone ready to start this fun-filled day? Outstanding. So welcome everyone and thank you for coming. Our third panel includes Mr. Shane Learman, Deputy National Legislative Director for Disability American Veterans, Ms. Quandra Patterson, Associate Director for Veterans of Foreign Wars of the United States, Mr. Zachary Stoltz, partner at Chisholm, and Kilpatrick. I will please ask all witnesses to stand and raise your right hand. Do you solemnly swear that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth, so help you God? Please be seated. Thank you, and let the record reflect that all witnesses answered in the affirmative. Mr. Learman, you are recognized for 5 minutes to present the testimony of Disability American Veterans.
Thank you. Chairman Luttrell, Ranking Member Pappas, and members of the subcommittee. DAV is grateful for the opportunity to appear before you today, and our written testimony covers the 10 bills being considered. However, my comments this afternoon will focus just on a few of these. Mr. Chairman, DAV is a congressionally chartered and VA-accredited veteran service organization that provides VA claims and appeals representation to veterans and their families at no cost. H.R. 3790, the Justice for ALS Veterans Act, would provide the DIC kicker to survivors of veterans who died due to service-connected ALS. If a veteran is 100% disabled 8 years prior to their death, the survivors will receive an additional monthly DIC payment, which is commonly referred to as the DIC kicker. Individuals diagnosed with ALS usually live only 2 to 5 years after diagnosis. Sadly, many veterans are unable to meet DIC's 8-year requirement for their families to receive the kicker. The Justice for ALS Veterans Act would provide the kicker to families of veterans who die due to service-connected ALS, regardless of the 8-year period. Mr. Chairman, DAV strongly supports the Justice for ALS Veterans Act, which is evident by the over 24,000 emails our members have sent to Congress in support of this legislation. We must ensure veteran survivors and their families receive the benefits they deserve and are not penalized from receiving increased compensation due to the rapid progression of ALS. H.R. 5890, the Review Every Veteran's Claim Act, would not allow VA to deny a veteran's claim solely based on failing to report for a VA exam. VA will deny a claim for increase, for example, based on that missed examination. Although the evidence of record may contain sufficient evidence for that increased evaluation, VBA will deny based on that failure to report. Mr. Chairman, for over 25 years as a VA-accredited benefits advocate, I have personally seen thousands of claims denied just for this reason. This is legislation that could be a game changer. Not only would this impact claims for service connection, but would apply to all claims for a benefit under VA's jurisdiction. We believe the Review Every Veterans Claim Act would be applied to other claims, such as total disability based on individual unemployability and aid in attendance. DAV strongly supports the Review Every Veterans Claim Act, as it would provide meaningful reform to the claims process while ensuring VA's decision-making process is based on the entire evidentiary record. H.R. 5938, the Veterans Exam Expansion Act, would expand license portability for VA contract examinations. Specifically, it will allow and extend the ability for certain medical professionals to provide VA claims examined across state lines. The current license portability expansion that began in January of 2021 has resulted in over 1,400 providers completing over 150,000 medical appointments and over 425,000 disability benefits questionnaires. This legislation would expand the license portability for psychologists, podiatrists, dentists, and optometrists, as well as extend the authority from 3 to 5 years, expiring in January 2026. Previously, DAV recommended that the license portability be made permanent and that all medical professionals that are able to conduct VA exams within the Veterans Health Administration be included in a permanent extension. Mr. Chairman, DAV fully supports the Veterans Exam Expansion Act, as license portability has had a positive impact for veterans living in highly rural areas, tribal lands, and incarcerated veterans, all while assisting in reducing the backlog of examinations, which has a direct impact on the backlog of claims. We urge swift passage as the current authorization expires in January 2024. Mr. Chairman, this concludes my testimony, and I look forward to any questions you and the subcommittee may have.
Thank you, Mr. Lehrman. Ms. Patterson, you're now recognized for 5 minutes to present the testimony of the Veterans of Foreign Wars of the United States.
Thank you, Mr. Chairman. Chairman Luttrell, Ranking Member Pappas, and members of the subcommittee, on behalf of the men and women of the Veterans of Foreign Wars of the United States, to include its auxiliary, thank you for this opportunity to provide our remarks on legislation pending before this subcommittee. The VFW views on today's bills can be found in my written testimony. I will take the opportunity to highlight a few of them. The VFW supports the Review Every Veterans Claim Act of 2023 that limits the authority of VA to deny a claim of a veteran for benefits on the sole basis of failure to appear for a medical examination. VA has made significant improvements to ensure filing for service disability compensation is easier for veterans. However, one of the major frustrations that remain for veterans is the practice of denying benefits due to a missed medical examination. The VFW has assisted countless veterans that have had to reapply for benefits because they fall within this category. Life happens to us all, and competing priorities can at times make it impossible for a veteran to make the scheduled examination. Restarting a VA claim for this reason is unnecessary, and veterans would benefit from a process that does not place so much power in a missed appointment. We look forward to working with the subcommittee to address our concerns. Fraudulent practices and growing scams are plaguing the veteran community as compensation measures are approved by Congress to provide for those who served and their families. The VFW continues to stand against predatory acts and for making victims whole who will have experienced predatory advances. Our position on fiduciary matters is unchanged from previous testimony, but it bears repeating. The VFW supports H.R. 4016, Veteran Fraud Reimbursement Act, and H.R. 4190, Restoring Benefits to Defrauded Veterans Act, that seeks to restore benefits to veterans and their families who are victims of abuse or fraud by fiduciaries. Historically, VA could make automatic payments only when veterans were defrauded by their fiduciaries in certain cases. A provision within the Isaacson Enrolled Veterans Healthcare and Benefits Improvement Act of 2020 intended to correct this inequity and allow for automatic reimbursements in all instances of fiduciary fraud. It has also created a requirement for VBA to make a negligence determination and for VA to investigate its own culpability in all cases of fiduciary misuse before reissuing payments to beneficiaries. According to a 2021 OIG report, it took VBA an average of 228 days to complete misuse determinations on 40 cases. Some cases took a year or longer. These delays perpetuate hardship for many veterans and their family members who are eligible to receive these benefits. We support this legislation that seeks to provide relief for this already vulnerable population. The VFW supports H.R. 4306, Michael Lecik, Military Firefighters Protection Act, to establish presumptions of service connection for diseases associated with firefighting. Many military firefighters report the use of firefighting foam in training operations and the presence of PFAS chemicals in bunker gear. Our members who served as military firefighters reported continuous exposure to these chemicals during training and face a significant occupational risk due to health hazards. We have a suggestion to expand and improve the language of this legislation so all veterans exposed to these chemicals are provided with the care and benefits that they have earned. We believe that the 5-year requirement as a firefighter is too long, as it only takes one exposure to cause harm. Additionally, there should not be a time limit for when the veteran can file a claim, as many of these conditions manifest years after exposure. This legislation is incredibly important to prevent PFAS from becoming another situation like Blue Navy or Camp Lejeune, in which veterans became sick and died waiting decades for their conditions to be properly recognized and appropriately treated. Chairman Luttrell, Ranking Member Pappas, thank you for the opportunity to provide my remarks. I look forward to your questions.
Thank you, Ms. Patterson. Mr. Stoltz, you're now recognized for 5 minutes to present the testimony of the Chisholm and Kilpatrick.
Thank you, Chairman Luttrell, Ranking Member Pappas, and members of the subcommittee. Good afternoon. I'm Zach Stoltz, a partner with Chisholm and Kilpatrick. CCK is a law firm with dozens of VA-accredited attorneys and advocates handling VA benefits claims at all levels of the process. I have personally spent the bulk of my career practicing before the U.S. Court of Appeals for Veterans Claims and the U.S. Court of Appeals for the Federal Circuit. I would like to focus my opening remarks on the procedural issues contained in some of the proposed bills. The Appeals Modernization Act has brought with it both good and bad so far. Good, faster decisions at the regional office, more choice and control for our veterans. Bad, some massive delays at the Board of Veterans' Appeals due to complications for both adjudicators and veterans with simultaneously running procedural systems. H.R. 5559, Protecting Veterans Claims Option Act, would have a positive effect on the VA adjudicatory system. Amending 38 United States Code Section 5108 and requiring VA to adjudicate all supplemental claims filed within 1 year of the original decision without a requirement for new and relevant evidence would help to advance the non-adversarial nature of the VA claims system. The bill also has provisions close to my heart as an advocate who handles cases at the CAVC, the amendment to 38 U.S.C. 7113. This amendment would aid the thousands of veterans whose claims are sent back to the board on remand from the court. The amendment would put AMA veterans on the same footing as their legacy counterparts by providing a 90-day period in which the appellant could submit evidence directly for board consideration. Appellants are currently sent back to the lane from which the appeal originated. This process leads to a number of scenarios in which efficiency is reduced, and it subjects veterans to needless shuffling around VA. Even worse, it costs many veterans their place in line at the board, because in the AMA, veterans do not retain their docket numbers once the case is sent back to the regional office. It may seem esoteric, but if the board decides, for any reason, to remand a veteran's case back to the regional office, the veteran has to start the appeal process to the board at the very end of the line. Given the 3 to 5 year delays at the board that we already know about, this is devastating for pursuing appeals. This amendment to 7113 is certainly a step in the right direction and will help get the right issues before the right adjudicators at the right time. And speaking of board delay, until recently, the only appeals being decided in the AMA at the board were those cases advanced on the docket for advanced age, severe financial hardship, and serious illness. But what about everyone else? It is unclear sometimes what is happening at the board. Combining H.R. 5559 with Section 3 of the Veterans Appeals Transparency Act, 5870, would mandate more transparency at the board that is critically needed. In my written testimony on this subject, I mentioned the frustrations we encountered in attempting to get basic information for how the board was adjudicating appeals. This section is a good step in requiring more transparency and better information from the board. And last, for my opening remarks, I would like to offer support for H.R. 5891, the Veterans Appeals Decision Clarity Act. Under the proposed amendment to 38 U.S.C. 7104, when the board declines to consider evidence because it was not received during a period permitted under Section 7113, it would be required to, quote, identify the time when such evidence was received and provision of Section 7113 of this title that establishes that such evidence may not be received at such time. In other words, the board has to let a veteran know when evidence came in and that they cannot use it. It would also require the board to state the adequacy of the timeliness of a notice of disagreement. All of this is essential for veterans and their advocates to navigate this very complicated system. I would also suggest that it would be better for personnel at the board and at the regional offices. It could cut down on unnecessary claims, questions, and requests from veterans. It is always good to remember this is a non-adversarial system. There's no traditional discovery. This puts veterans in a position to understand what is happening in their cases, both substantively and jurisdictionally. Thank you so much for the opportunity to be here today, and I look forward to your questions.
Thank you, sir. We'll move into our first line of questions. So, Mr. Stoltz, do you agree with the VA's statement that board decisions on appeals would be delayed if we required the board to provide a general statement about the timeframes during which untimely evidence was submitted?
No, I don't quite understand, and with all due respect, and I know the Board of Veterans Appeals has a Herculean task, and I do not in any way want to advocate for something that would slow them down. From where I sit, and it's just from where I sit, they have to do this work anyway. The board member and their staff is going to have to go through the evidence that comes in. They have to do it, writing it in 1 or 2 sentences, I think, as you pointed out, Mr. Chairman. I don't see how that would slow down the board in any meaningful way. Would it create a little bit more typing? Yes. Would it slow them down in a meaningful way that will affect veterans? I do not see it.
Okay. What happens when the board sends a veteran a letter rejecting their notice of disagreement?
Well, what happened in the case before the court is it becomes very confusing, and the veteran, and it's happened several thousand times, so I don't know that there's one simple case. I can talk about the one.
I'm sure everyone's different.
Everybody's different, right? But it's confusing because you get this, you don't get appeal rights, and you get a letter from probably, in the way that I understand that it was working, and I understand that perhaps some of it has been fixed, but the way that it was working in what's a publicly recorded case is administrative staff sent a letter. Veteran got very confused by it. You try to fix it through the board, then the board issues a decision that should have appellate rights, and then you get your day in court. But the fast answer is you get something that you can't appeal. You cannot appeal.
Cannot.
That is my understanding.
Can the veteran appeal the rejection letter to the court? You said no.
Not directly. They have to go through the board, and then the board would have to issue a decision.
Do you think that a veteran should have to go through the extra hoop of disputing a rejection letter from the board administrative staff in order to receive a board decision by a board judge that the court can review for accuracy?
I do not.
Mr. Learman, how would the Review Every Veterans Claim Act help veterans who are filing claims other than original claims for compensation, such as claims for increased compensation?
Thank you. Actually, it would have a big impact. Whenever a veteran files a claim for an increased evaluation when the condition has grown in severity, VA automatically is going to order them an examination if there is no evidence currently to grant that increase. So in a lot of cases, if the veteran fails to report for the increase, VA will automatically deny it from that part because they requested the exam solely for the increase. So then we have to come back and say, well, no, actually the veteran tried to reschedule the exam, and for some reason that didn't get relayed. So now we have a denial. So now we got to find a way to fix it to where if they can't deny it solely for that reason, the veteran is going to have more continuity or more time to continue to through the process without being just stymied up front for failing to report.
Okay, thank you. Mr. Travis?
Thank you, Mr. Chairman. Thank you all for your comments here. I think these are all incredibly helpful as we go about our work. Ms. Patterson, maybe I could start with you. We heard earlier from Representative Issa about his legislation, the JAX Act, and I understand that VFW supports the bill, and a lot of us up here do. But from my perspective, the constraints on eligibility in the bill make it narrow, and it leaves people behind, for example, the Lioness teams of Iraq in 2003. So my question is, should we be looking to improve the bill to make sure that we don't continue to leave groups of women veterans behind?
Thank you for that question, sir. VFW also agrees that if there are other categories of veterans out there who've experienced similar situations to where they're not included, that we do revise the bill or that we do things to make sure that they're included.
Thank you for that. Similarly, the way the bill is drafted causes some confusion as to who's eligible under the bill, and particularly it seems to limit eligibility to veterans who have previously filed a claim and had that claim denied. We all know that veterans often decline to file a claim in the first place because of the perceived futility in some cases of doing so. So I imagine that it's particularly true for the women that we're discussing today. So I'm wondering if VFW would support removing the requirement that a veteran must have previously filed a denied claim in order to be eligible under this JAX Act.
Absolutely.
Okay. Mr. Learman, I see you nodding as well. Would you provide any comments on that legislation?
Yes, and thank you. I think once they determine that they have combat exposure, everything is applicable at that point. So I don't think it would just, they would have to have been denied before. I think that presumption of combat, which is so important to help veterans establish benefits, I think that would override what their language writes, but we would be supportive of correcting that. And when there are a group of other women veterans that fit those categories and criteria under DOD, absolutely, we think it should be expanded.
Thank you for that. And maybe I could follow up with you about a separate piece of legislation. This is Representative Slotkin's bill, the Justice for ALS Veterans Act. I understand that DAV supports the bill, has mobilized its membership to reach out to their member of Congress in support of the legislation, so we thank you for that. One provision instructs VA to identify other diseases or illnesses with similar characteristics of fast progression and high mortality, and that also may deserve similar treatment to what's being proposed for ALS under the bill. So can you talk about DAV support and what other conditions that you may see that we should consider with the same treatment as ALS under this legislation?
Thank you. And to just real quick to make reference to what was discussed earlier, we believe that it's already, ALS in itself meets the criteria of a rapid progressing disease because once a veteran files a claim for it, it's an automatic 100% disability evaluation within the VA. So we think that meets that already, especially when you look at the average of 3 to 5 years from the diagnosis until the veteran passes. Other conditions, pancreatic cancer, which is now a disability presumptive to the PACT Act, would be one other disability that I would clearly mention because of its devastating effects and sometimes its late manifestation. So it does progress very rapidly.
And I'm sure you must have members that either have ALS or have firsthand knowledge about how terrible this disease is. I'm wondering if you also could provide some comment on what the additional DIC payment would mean to survivors of veterans who suffered from ALS.
When the veteran passes, the family no longer gets the veteran's compensation. So the family and the surviving spouse would have to apply for what we often refer to as DIC or Dependents Indemnity Compensation. Right now, that's about 40% of what a 100% veteran receives. So it's a great reduction in their income. Making them eligible for this additional compensation, or the kicker, is going to help improve the quality of life for that family after the veteran has passed.
Thank you very much. I yield back, Mr. Chairman.
Thank you, sir. Mr. Crane, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you guys for showing up. I realize we're here today ultimately to make sure that our veterans are taken care of. And I do believe that the vast majority of people in this room and at the VA as well try and do everything they can to take care of our veterans. That being said, there are circumstances where that doesn't happen, and I think that's one of the things that we're looking into today. Were you guys in the room when I was asking the panel before you about accountability? What did you guys think about the responses that I was getting? Ms. Patterson, I want to start with you. Did it sound like there was any accountability whatsoever as far as, any counseling, documentation being put into records? Clearly I was just asking for, hey, can you tell the panel what happens when people at the VA make mistakes? What do you think of that, Ms. Patterson?
Thank you for that question. The VFW thinks that accountability for veterans, whether it's in the processing of the claims or for those who are involved in the process of processing of the claims, the more clarity that is out there, the more that it can be clear that this is the consequence to failing a veteran in this process, the more proficient the process will be.
Yeah.
And so I did not hear where there is a process or what that process is. I didn't think you were asking for names. You were just asking for what is the process? How do you determine who's accountable, and if people who are doing things wrong, if they know that if they don't do certain things that there is a consequence. So we would like to see also a clear, process that does hold people accountable, just so we can ensure that the veterans are being taken care of.
Thank you, Ms. Patterson. Mr. Stoltz, you realize this is an oversight hearing, right?
I do.
Do you think that that's appropriate, that, those of us that are tasked to not only fund the VA, but also conduct oversight of it, be given reasonable answers to questions such as, is there any accountability when individuals at the VA make mistakes?
I do.
You do? Did you think that the answers that this panel was given are acceptable?
I did not hear a direct answer to your question, Mr. Crane.
Did it sound like I was asking for specifics, specific names?
It did not.
Okay. What about you, sir, on the end? Learman, Mr. Learman?
I don't believe the question was answered, to your point. There was no actual discussion on the accountability. And again, I've been doing this for 25 years for DAV at 5 different locations around the country. We reviewed rating decisions, would find problems, take them back to coaches, people within VA to explain an issue. And when it comes to accountability, my experience has been it's there. It just may not move nearly as quick as we want it to, or have the correct measures that we deem would be appropriate.
Yeah.
So accountability is a big issue for us, but I think sometimes it's hard to actually see it take place.
Thank you. And I want to reiterate that I don't believe that the vast majority of employees at the VA are making mistakes or making mistakes on purpose. I do believe that they try and do a good job. And I agree with the chairman who said that we understand that the individuals sitting on that panel have a very daunting and difficult task. This is a huge organization. But as somebody, who came from the military myself and then started a small business, I can tell you that when we had employees that, continually made mistakes, we tried to document those mistakes, have a counseling, and, made sure that went in their personnel file, so that if we continue to see the same mistakes over and over and over again, we could take, follow-on actions, and possibly, if it got too bad, even termination. But it is disappointing when we have these oversight hearings, and we're not just talking about products being made like at my company, we're talking about actual veterans, their families, their health, their lives. And if there is no transparency or accountability, it makes me understand why I hear the same things from veterans in my district over and over and over again about the type of care that they're receiving, the type of communication they're receiving, the type of transparency that they experience. Thank you. I yield back.
Thank you, Mr. Crane. Ms. Ramirez, you're recognized for 5 minutes.
Thank you, Chairman. You know, in the panel right before this, I mentioned that one of the priorities for me is to ensure that we continue to recognize the service of women. And I certainly just want to follow up on a few questions related to female veterans, and then I want to move into a couple of other things. Mr. Learman, can you speak to the importance of women veterans being fully recognized and how recognition in combat can result in access to benefits?
Absolutely, and thank you. As we were discussing earlier, the presumption of combat will open up doors to where a veteran won't have to prove a specific disability as long as it's consistent with the hardships of combat. That's why this is such an important presumptive. So getting people recognized, women veterans who may not have been recognized before as at combat, this is going to help their ability to get claims granted, to not have to be burdened with an over amount of evidence to prove it, and it's going to streamline the process for them to get access to those benefits. In reference to women veterans as a whole, DAV has been championing this particular issue for women veterans for decades. We came out with a Women Veterans Report in 2014, 2018, and we're currently going to be putting out another Women Veterans Report, going to be focusing on the importance of mental health and women veterans, and we're hoping to have that out in March or April of next year, and we will make sure the committee gets a copy of it.
Thank you. I was about to ask you when we can expect it, so thank you. I appreciate that. I want to shift gears a tad bit, and I want to go to your testimony. In your testimony, you state that the Director of Claims and Fiduciary Inspection Division, the Office of Audits and Evaluations of the VA OIG, mouthful, confirmed that negligence determinations by the VA do not have a specified time period and that beneficiaries are waiting more than 400 days for reimbursement of misused funds. So my question for you is, can you describe how this wait time is impacting veterans?
It's a matter between paying their rent, buying groceries, getting prescriptions, because once that misuse has been done, they stop making any payment.
Yeah.
So now that veteran's family is not getting any compensation payment for that 400-day period until they either make a determination of the misuse or establish a new fiduciary and then set up new funds. So we're talking potentially, a year and a half of a veteran's family not having direct access to compensation just for the basic daily needs.
Yeah. You could imagine in that year and a half where shelter, where food, with basic needs, and the impact that they have. I ran a homeless shelter, so I can tell you I've seen the impact of both female veterans and male veterans. I want to ask you just a few more questions before my time is over. Does your organization work with veteran fiduciaries?
DAV provides free representation for veterans and their families. So we have and do represent veterans that have fiduciaries, and I have interacted and represented them myself multiple times over the last 25 years, and our organization does on a daily basis.
Okay. What does this procedural fix mean practically for veterans and their families?
Well, it's giving them access back to their compensation. I mean, fiduciaries do a very difficult job, and when there is a decision of misuse or waiting for it, that slows down what the fiduciary can do, but more importantly, slows down the access to veterans and their families for the money. So this fix would give them access to their compensation much faster than waiting for that determination.
So I got a little bit about 45 seconds left. I'm going to give you 30 of those seconds to share with us here to the committee. Is there any suggestions you have for additions or changes to the current legislation we're discussing or any other legislation before us today? Go.
Oh, thank you. The Michael Lecik bill, DAV does not support it. We're a resolution-based organization, which means we must have a resolution to support it. So we don't support it or oppose it. But we're really concerned with the 5-year must have served on active duty, then your disability must have been diagnosed within 15 years in order to get it service-connected. When we do that to presumptives, what we're doing is limiting and restricting the number of veterans who are actually going to be eligible. If we want to do this to provide that benefit, we need to remove it. The other part of that I want to mention is,
I'm out of time, but I'm gonna take what you gave us before the chairman rings the bell. But I would love for you to be able to provide any of the other additional information if it's not the testimony in writing. Thank you, Chairman. I yield back.
Yes, ma'am. Mr. Pappas, closing remarks?
Well, thank you, Mr. Chairman, for convening this hearing, and I want to extend my gratitude to all the members and witnesses who participate in it. I appreciated all the insights that were shared, and I think this hearing highlighted some important issues. We received an abundant amount of feedback that's going to help us ensure we're working together on the bills that were put forward. And I believe that both Republicans and Democrats share a genuine commitment to enhancing the well-being of veterans, and I also believe we need to continue to uphold our promise that we made to veterans and their families who may face challenges in accessing the benefits to which they are entitled. For me, these benefits are vital in safeguarding the dignity and well-being of all those who have served this great nation. So in advance of Veterans Day this weekend, I want to thank all those who have served this great country and who are serving today in uniform, and extend my gratitude to our panelists for their insights. And I want to thank all my colleagues for their contributions. Let's keep working together on these bills and see what we can get done here. Thank you, Mr. Chairman. I yield back.
Thank you, sir. I look forward to working through these issues with the department and my colleagues on the subcommittee. The bills discussed today would provide important improvements for veterans going through the veterans claims and appeals process. They would also improve access to benefits for groups of veterans who earned their benefits. As I said before, the complete written statement of today's witnesses will be entered into the hearing record. I ask unanimous consent that the statements for the records submitted from the following members and organizations be entered into the hearing record. Representative Gerald Connolly of Virginia, American Veterans, AMVETS, National Organization of Veterans Advocates, NOVA, Paralyzed Veterans of America, PVA, Quality, Timeless Customer Service, QTC, Special Operations Associations of America, SOA, ALS Association, Service Women's Actions Network, SWAN. Hearing no objection, so ordered. I ask unanimous consent that the letter of support for military veterans advocacy is entered into the hearing record. Hearing no objection, so ordered. I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and include extraneous materials. Hearing no objections, so ordered. I thank the members and the witnesses for their attendance and participation today. I thank all the veterans and their spouses and families in the room today for showing up. God bless you. Thank you for your service. Happy Veterans Day. This hearing is adjourned.